Hello, welcome to Legal Action. My name is David Siegel. Thanks for joining us today. We're going to be talking about the Illinois mortgage foreclosure law, which is a hot topic right now as many people are facing foreclosure or in foreclosure. Along with my co-host Jesse Barrientos, we are honored to have Judge Jesse Reyes. Jesse Reyes, welcome.
Thank you, David. Thank you. It's a pleasure being here. Thank you, Jesse.
Thank you. We're going to be talking, Judge, with, you're very familiar with this area. Obviously, you're sitting on the bench in Cook County in the Chancery Court, handling mortgage foreclosure cases and commercial foreclosure cases on a day-to-day basis. And we wanted to talk with you about some of the things that you're seeing so that our listeners and viewers can be advised on what they can do and how homeowners can be helped or how they have certain remedies available. So that's where we're going to start off. Jesse?
Yeah, we've talked about in our last program a lot of things, which I think one of the most important things, somebody had mentioned that, was the help that's available. You're not out there by yourself. There is help, but you can't bury your head in the sand. You have to avail yourself of that help, and it would be much better than just ignoring it altogether and just dealing with the consequences that it happens with.
Exactly. And, one of the things I should mention also, unfortunately, like in a lot of areas where sometimes there's some distress and some opportunities to take advantage of people, there are some scams. So I would suggest, like in regards to the modification, make sure that you know that you're dealing with a reputable company or a reputable person who is knowledgeable in terms of doing foreclosures. And particularly with regards to the modifications. So if there's a question, you have an issue, they could contact the Attorney General's office, and the Attorney General could advise them whether or not it's a reputable company that they're dealing with. Because unfortunately, sometimes that's what we hear, is that someone went to a company that's not a reputable company and they're being scammed.
I think there's been some recent activity on that front where these companies cannot accept a fee up front. Unless they're a lawyer or work for a law firm or something along those lines.
Exactly. They can't ask for a fee up front, and unfortunately sometimes we've heard of situations where individuals have done that, and the Attorney General is looking into those issues. So,
sure. Yes. Let's talk about some options for the homeowner who's in foreclosure. They've been served, they're in court, they're nervous, they're worried about losing their home, or they're worried about owing money on their home and being putting out on the street. Let's just talk about a couple of those, if we can start with the deed in lieu of foreclosure.
Right.
What is that for the homeowner?
So there's a deed in lieu. What happens is that you're not able to pay your mortgage anymore, and you could approach the bank and tell them that, basically what you're doing is you're going to give them back the property. You'll sign a deed in lieu of the foreclosure, and then they'll have the property, and then you'll basically waive all your rights to the property, of course, but then they'll forego the foreclosure.
So you're out, and then you won't owe anything else. You're out of the whole deal completely, and you walk away, they walk away, and everybody is well, not really even, but
not really
you don't
even,
have to worry about.
But the foreclosure is resolved.
Okay. And on certain occasions, my understanding is that the homeowner may actually receive a stipend to keep the property in good repair, and turn over the keys.
In some situations, they'll give them a stipend to stay in the home, because one thing that I think everybody has to realize is banks don't want to be landowners. They don't want to be the landlord. But in some situations, they don't have a choice. But however, in the deed in lieu, if they can work something out, or in terms of also maybe working something out when you're going to vacate the premises, you could negotiate that with the bank as well.
Sure.
In the deed in lieu.
It's particularly important, too, because you mentioned they don't want to be landowners, because there are so many properties out there. And what we find, what I've seen, too, in terms of people buying foreclosed property, and I mean, obviously there's a whole bunch of different things that people do, where what happens is eventually the power goes out, the grass grows, the weeds get up there, and they're fined by whatever municipality or city they're in because the power goes out. Now there's a flood, and now all of the heater and the boilers, everything is now destroyed because you have those situations. But when you buy them like that, if you do, it's as you are. So it's very advantageous for both people to be able to try to work something out to avoid those consequences.
Right, and in the last program we talked about the commercial foreclosures, and one of the things that's occurring a lot in commercial foreclosures is that the banks are asking for the court to appoint a receiver, which is an individual that will oversee the activity of the building. Let's say, for example, it's a rental building, and so the receiver will be the individual that'll collect the rents, maintain the premises, address any issues that there may be with regards to the building, or any code violations, oversee any code violations or repairs. So if you happen to be a tenant in a building, this individual will provide verification that they're a court-appointed receiver, but that's what their purpose is, to take care of that.
What happens if I'm not in a position to do a deed in lieu of foreclosure for somehow that doesn't happen? But let's say I just want to, you filed the foreclosure. I don't want to fight here. You know what? I just want to go on my own way so I can consent. Is there a way for me to just consent?
There's the consent foreclosure as well. Again, that's another option that individuals may have, particularly in a residential foreclosure, where they basically will concede that they do owe the amount that the bank is stating, and they just basically sign away their rights to the premises.
Is that the possession? Am I still going to be on the hook for I guess that would be the deficiency of whatever they may happen to sell it for?
Well, now that's something else. There are a variety of different deficiencies that may occur. There's what's known as the in personam deficiency, which is a term which means that you yourself are going to be responsible for the deficiency, and then what's known as an in rem deficiency, which means that at that point in time, it's a technical term, which means it follows the property, but the person, the mortgagor, is not responsible for that deficiency. And those deficiencies are determined at the time when the property goes to a judicial sale.
That's a great segue, because that's our next topic. A lot of people feel that once the sale occurs, they have to quickly vacate the property. What is the reality there, Judge, vis-a-vis a sheriff's sale?
Okay. So first of all, what will happen is in a commercial foreclosure, 99% of the time, the mortgagor has waived their right to redeem the property. And in a residential foreclosure, what happens is you still have the right to redeem, but then when the property goes to sale, they have to notify the world. They have to notify the world by putting publication in the newspaper, one in a general newspaper, and that's usually like the Chicago Daily Law Bulletin, and then the other one in an area where the premises is located, so the local newspaper. So in this area it might be the Daily Herald. So they have to put a publication, and they have to indicate where the sale is going to take place, what time it's going to take place, and the information about the property in terms of the commonly known address and then the legal description. And it has to run for at least 3 consecutive times. So this way, everyone knows that there's a sale taking place. But particularly, it's for the mortgagor and then anyone else who may have an interest in the property. Then it'll go to an auction. At the auction, depending on what happens at the auction, if the amount that's due and owing under the debt is not satisfied, then there's what's known as a deficiency. So the bank will then present to the court a motion seeking an order proving the sale. Now that motion will ask the court to approve the judicial sale that took place. They'll also submit a report indicating this is what was due and owing, these were all the interest that was due and owing, and any other costs that may be associated with the property, and how much was actually bid, and if there's a deficiency, how much the deficiency is. Now that goes out to the mortgagor and anybody else that had an interest in the property. What happens sometimes is that it goes to the property. It's mailed to the property. And sometimes tenants will receive that notice of motion. many times they come to court, they don't know what's going on. In fact, sometimes that's the first time they find out that their property, the building that they were living, is being foreclosed. So they'll come into court. What's significant about the order is we look at who is named in the order in terms of possession. If they're only seeking possession on a residential foreclosure regards to the mortgagor, the person that owned the mortgage, and no one else, then the tenant is not affected at that point in time. The order also provides for 30 days, which means that the bank could take possession of the property within 30 days after the order's entered. So if I entered it on the 1st, on the 30th day, the bank could take possession. The other thing that's significant about the order is that they provide, in some cases, what's known as a special right to redeem, which means you still have another 30 days. The order will provide for 30 days. Another 30 days to try to work something out with the bank, so you could still properly maybe try to redeem the property.
Even after the sale?
Even after the sale. But the order has to provide for the special right to redeem. So those are some of the things that a mortgagor who is in a residential foreclosure has to look at to make sure that, they should come to court if they want to exercise their right to redeem, or they have an issue about possession. They could address the court about, that type of issue. Also, the order provides for information in terms of identifying the property, so this way you know that it's your property as well. Because sometimes you're not sure if it's your property or not, because you may have moved to another location. You get a notice, so all this information has to be in the order approving sale.
So if for example, I'm a tenant, like you said, and I just find out for the first time because they mailed it to the property, and I've got a lease. I haven't been named as a defendant in the action. They can still oust me from.
Well, the order at that point in time, when the order approving sale is entered, will not affect your possession of your leased property. However, the bank can, at a later date, come in on what is known as a supplemental petition for possession, and they could name you and anyone else who's in the building and try to seek possession of the premises as to you. Now, if you're a tenant and you've been current on your rent, which I think is important for people to realize, they should save their receipts, and you show the bank that you're current, then you can still try to stay in the property, and depending on the circumstance, up to 120 days.
This supplemental proceeding that you're talking about, Judge,
Yes.
is this basically a forcible detainer action within your court?
Right. Yeah. We do not in the Chancery Division, the mortgage foreclosure section. We don't hear the forcibles. Those are heard in a different part of the Daily Center. But yes, it'll be a forcible entry and detainer action that the bank will bring to try to get the supplemental possession.
But within your court?
Right.
So you have to be versed on all the forcible detainer statutes as well as the mortgage foreclosure law, correct?
Right, but we don't hear the supplemental petition hearing. We don't hear it.
Oh, okay.
They go to a different division than for that.
Oh, okay. I thought
Right.
they'd bring it back in
No,
front of
they
you.
don't bring it back before us. No.
Okay.
We were talking before, and I think it's important for the folks at home to know, what happens if I have a problem with the language. If maybe I don't speak English very well.
Yes.
And a lot of times that really deters people from doing a lot of things. What happens even if maybe, I might not necessarily even be a citizen, or I might be worried about those kind of things. I shouldn't worry about appearing in court for this foreclosure action. Am I going to have an interpreter available to me?
If you speak a language like, say, Spanish or Polish, we have interpreters in the building, and they assist all the judges. If there's another language that might be a little more exotic, that for example, I say Mandarin, or then we'll get an interpreter. Usually, what we'll do is we'll continue the case because we could get an interpreter. They're not readily available in the building, but we'll continue the case and then provide an interpreter. So there are interpreters, there are court interpreters that are available in the Daily Center, and they do assist in the matters pertaining to foreclosures. So if you don't speak the language very well, or you have problems speaking it entirely, we have interpreters that'll assist with the translation.
So I shouldn't feel. I want the folks at home to understand that, because a lot of times, that's the kind of population it really hits, and so they should understand that. Hey, listen, you need to come to court. We're not just going to the judges aren't just going to brush you off because you don't speak the language.
Right.
They're going to provide that communication link.
And it doesn't matter what language, because I've had situations where someone speaks Hindu, they speak Mandarin, Cantonese, Russian, and we don't have Russian interpreters readily available in the building, but the court will provide the interpreter.
Yeah.
We talked about the sheriff's sale date, and then the secondary date after that is to come before you and ask for the sale to be confirmed. Yes. My question is this, Judge: if the sale produces, or if the mortgagee is owed $300,000 on the note, and a third-party buyer doesn't bid, and the mortgage company decides to bid it back for $200,000, there's a $100,000 difference there that now they're possibly seeking a deficiency, personal deficiency against the homeowner. Now, the law provides for it,
right?
But my understanding is right now in Cook County that's not available. Is that true?
No. The law provides for in rem or in personam deficiency. However, the matters that are presented before us in terms of order of possession on the residential foreclosures normally don't ask for in personam on the residential foreclosures. Where we see the in personam foreclosure deficiency coming into effect is in the commercial. But that doesn't mean that we don't hear any in personam, because on occasion we do see an in personam. But the statute requires, and it's very strict in terms of the requirements. Number one, the party you're trying to seek the deficiency against in personam has to have been personally served. All right. Number two, it has to be a relief that you sought from the beginning in terms of your complaint, and it also has to be set forth in the judgment of foreclosure. And then we also require, in the section, the judges require a BPO, which is a broker's price opinion. So this way we could determine whether the property that went into the foreclosure sale is the value and was sold comparably for what everybody else's property is worth in that area. So once you provide all of that, then the court will consider whether or not to grant your in personam deficiency. But do we see a lot of those in Cook County? No. Very rarely do we see them under residential foreclosures. But we do see quite often on the commercial foreclosures the in personam.
So, and again, I just wanted to make sure. So in personam, basically, that means, hey, I'm going to owe that amount of money.
Right.
In rem means it kind of follows the property.
Right.
So
Correct.
we don't have to worry about that.
Correct.
So, and again, what I'm hearing, I just want to make sure that they understand at home that if the bank doesn't do these things in the beginning and allege them in the complaint, now the foreclosure's done. Now, is it correct then that they cannot come after me for the deficiency then, or?
Well, again, if it's not asserted in the complaint in terms of what relief they want, they can't, unless they've amended the complaint, they can't come in later on and try to seek a different type of relief. So it'd be just like any other regular court action. You, as the defendant, have to know, what is it that you are responding to, or, what protections do you have with regards to what they're seeking against you. And if they're not asking for an in personam in the complaint, then, they can't ask for it later on unless they amend the complaint.
Then they're out of luck, and so I shouldn't then have to worry about it if they didn't ask for it as the person who's getting foreclosed on, that they would come back.
But again, I would suggest if you're a pro se, which means that you're doing this on your own, that you should definitely seek some type of legal advice and assistance, because you don't, again, like I said before, you don't want to assume anything, and I think that's part of something that could be damaging for you if you make assumptions, because again, you have to read the complaint and make sure that the entire complaint doesn't allege that, but I would say the majority of the complaints, I've never seen a complaint that doesn't allege some type of deficiency.
Sure. I had a question, Judge, particularly with regard to real estate taxes. If a homeowner hasn't paid the real estate taxes for a year or two and it goes through a foreclosure,
Yes.
and the mortgage company winds up buying the property back at auction, what happens with the real estate taxes? Was the county that it was located in just never receive it during that period of time, or does it stay with running with the land, and does the mortgage company have to make that up?
Again, it depends. I mean, sometimes what happens is, and this is where the foreclosure comes in. Some individuals have the taxes incorporated into their payment. So, if the foreclosure takes place and it was incorporated into the payment, that's one scenario. Another scenario is, and sometimes this is where it comes in, we have to be careful about who's actually bringing the action. When Bank A is the bank you went to and you obtained the mortgage from them, okay, and the taxes are included in your monthly payment, but then they assign it to Bank B, and then Bank B, for whatever reason, decides that they don't want to pay the taxes, right? You have to be careful as to who you're paying your mortgage payment to, and also with regards to that the payment is being applied correctly. Because sometimes what we see is individuals who come in and then they find out that there's a tax action against them because their real estate taxes aren't being paid, but they assume that they had their taxes paid in the mortgage payment and they were making their mortgage payment, but they didn't realize that now Bank A has assigned the loan to Bank B, and they weren't applying it. So they come in front of us, and then that matter gets litigated. So there's an issue sometimes with regards to assignments, and it's important with regards to the taxes, but also in terms of who is it that's bringing the action. Many times individuals don't realize they start out with one bank, and then now all of a sudden they get this notice of foreclosure, and it's from another bank, and they just decide to dismiss it and don't come into court. Again, it's important to come into court no matter what type of document you receive from no matter what bank, because your loan may have been sold to another bank, and then they're the ones that are proceeding against you with the foreclosure action.
Yeah. And in fact, a lot of times this happens right at the closing. I've done a lot of real estate before the bottom kind of fell out, and one of the documents that you sign is an indication. It's a notice that says that they can assign your servicing or sell the rights to that loan to somebody else right when you're buying the property. And again, maybe you said you don't know because you figure, I don't know who this person is. That's not the person I did the closing with.
And then if you're working on a modification, it's important to realize what bank you're dealing with, also because you may start off trying to contact Bank A with regards to modification, and in the midst of it, if they've assigned it to someone else, and you're not aware of it, you're still continuing negotiating with Bank A. Now you get a foreclosure action filed against you in terms of having a motion brought against you by Bank B. So it's like a bouncing ball. You have to kind of keep track of, but you have to keep track of it.
Yeah.
How about a case where a homeowner does hire an attorney who is insisting on making the mortgage company prove every single element, every single document? What percentage of those cases that you see will actually go to a full trial where someone will have to come in and testify about the mortgage documents, Judge?
Most of the time, they're resolved through either settlement or they're resolved through some type of a hearing. But I've been sitting on this call for since 2005, and I think during that time, in regards just to the plain foreclosure action itself, I've only had maybe 3 trials.
Is it just an efficiency thing where someone knows it's going to cost way too much to bring in people to go to a hearing?
I think it depends on the issues. For example, if someone's contesting that they were not properly served and their lawyer brings that before the court, that will be resolved through an evidentiary hearing to determine whether or not there was proper service. If there's an issue with regard to predatory lending, again, that might be a scenario where it's resolved through a hearing. So it depends on what the issues are that the parties are raising. We have a lot of lawyers who come before us who do an excellent job in raising the issues. Some of them get resolved just through rulings on motions, and some of them are resolved through hearings.
Do you engage in pretrials with the litigants? Do they have that opportunity to speak with you in chambers?
We engage in pretrials, but both parties have to be amenable and agreeable to the pretrial. But if all the parties are agreeable to the pretrial, then we'll engage into a pretrial.
I was going to say, too, it's important for folks to know, too, because a lot of times what you have is not just the foreclosure proceeding, but if you have a condo or a homeowners association,
right.
and you haven't, if you didn't pay your mortgage, you probably haven't paid them either, and then you have a separate proceeding for a forcible entry where they're trying to oust you in order to essentially rent your property to make payments for your back association dues and everything else.
Right. Many times in a foreclosure regarding a condominium unit, we will have, of course, the bank. Then we'll have the attorney for the condominium association there as well as the mortgagor. So, the fact that you don't pay your mortgage payment and you don't pay your assessment, all of that, will be heard by us in the foreclosure action, and then that's what happens. Sometimes they want to see if they can get in there sooner to try to take possession of the premises, but the foreclosure process itself has to work out. I mean, we still have to get a judgment, and we still have to have the property go to a judicial sale.
Yeah, real briefly, Judge, we just have a couple minutes left. I wanted to breach about the topic of emergency motions.
Yes.
Are you seeing emergency motions right on the eve of sale, and how do you handle those?
We see emergency motions, and we see emergency more so than we have in the past, and we will grant the request for an emergency motion. However, it has to be an emergency. It's not just something that it could be easily heard through a routine on a routine call or a default call or a contested call. So we are seeing those motions, and then it depends against what type of issues are being raised with regards to the stay of a judicial sale. Those are commonly what we see on the emergency motion call, and again, it depends on what's at issue. The parties are trying to work something out or things of that nature. But we do see a lot of emergency motions.
Okay.
Well, I was going to say one of the things, and you talked about doing bankruptcy too. On the eve of sale, if somebody files that bankruptcy, then everything is stayed.
Right.
And is there a bankruptcy call that it just gets continued for status?
That's all dealt with at bankruptcy court. So when a bankruptcy is filed, the parties will come in, and no matter where we're at in the foreclosure process, if a bankruptcy is filed, then we won't enter any orders until there's a stay or a modification of the bankruptcy. And sometimes this is what will happen. This is okay. So you file a bankruptcy, and then the bank will go in and seek a modification of the bankruptcy. So everything else may stay over at bankruptcy court, but they may get the foreclosure or the mortgage action removed from the bankruptcy, and that happens. Right.
Yes. Thank you very much, Judge.
You're
Appreciate you being here and giving you your time tonight. Judge Reyes alongside Jesse Barrientos. My name is David Siegel. We'll see you next time on Legal Action. You can reach us at LegalActionTV.com, and if you have questions at LegalActionTV.com. We'll see you next time. Thanks again, Judge. Thank you, Jesse.
My pleasure. Thank you.
Thank you, sir.
Very good.
Thank you.
Appreciate your time.
Thank you.